So the biggest change perhaps are these new application forms. And I have to say, when I first kind of laid eyes upon them in April, even, as a family practitioner who's, done this for a decade, I was shocked at the size of the forms. If some of you will remember, back in the day, an application form, I think, was like 2 to 3 pages. A notice of motion, I think, was a single page document. There are, 6 check boxes after where you fill in your, contact information, and you check those off and away you go. The new form certainly very much deviates from that. And I think, many of you are in support worker roles. The biggest hurdle, and I'm sure many of you have looked at the new forms and have had to work through them in the last few months. It's a daunting task. And I think, where my goal is today in assisting kind of your learning in these new forms is hopefully getting to a place where we all feel comfortable about the new forms, comfortable working with clients with these new forms, and just to make the process much less daunting. Because when you pick up a document that's like 55 pages long with like thousands of words inside, it can be extremely overwhelming. So without further ado, let's talk about these new forms. Now, of course, every single form is new. Some of them do look like their predecessors, the simple consent order forms, for example. But all these new forms have something special about them in that they have now all gone into a first-person question and answer format. This is great because it really allows people that to kind of provide their own narratives in a meaningful way. I've also noticed as part of the forms, they have extensive explanations on the left side of the form, on the back page of the form, that explains, what they're looking for. And I've found lots of helpful pointers in there. And I'm sure, as someone assisting another person in filling out those forms, having that, point by point guidance on the flip side of the form is very helpful. Now, especially with the initiating document, which is the application about a family law matter, there are tons of schedules. And again, initially, that could be a very daunting experience going through that form the first time, but you only need to fill out the schedules that apply. Now, let's talk briefly about the sequence of who files which forms to get a family law matter started in provincial court. The initiating party will file the application form, which is called Form 3. Now, all of these forms are helpfully located in the provincial court website as a fillable PDF format. From my experience, for those of you who might have access to a program called DivorceMate, they have like a version of the form that has clicking schedules. So that's very helpful as well for those of you who have access to that program. Otherwise, I've had other workarounds where, say, you need more space, you can attach just blank pages or typed up notes to the PDF application form if the fillable boxes are like too tiny and there's not enough space. Now, once the first party goes and files the application, the responding party will need to file their reply and also their counter application, which is in Form 6. The first party then will get a copy of that, and they will get an opportunity to reply to the application with the counter. And then from there, the next step is usually everybody attends a family management conference, which they get a date through the registry. Now, talking about the schedules, this is an excerpt of the forms. And throughout this presentation, I've put in various excerpts to the forms just to highlight some things that you'd be looking at. Now, Form 3 starts by, I'm applying for a court order about the following things. As you can see, you can choose parenting arrangements, child support, contact with a child, guardianship of a child, spousal support, These are the main schedules that are available. And depending on what you're looking for, say a totally new parenting arrangement order, and so you can see the new, that is a Schedule 1, so you need to complete Schedule 1. If there's already an existing order or agreement, then you complete Schedule 2, and so forth. So you can see there are 10 separate schedules, which explains why the form as a whole is like 50+ page long. So you only need to fill out the schedules that are relevant, and you can kind of discard all the other pages. Now, under the parenting time section, and I go into I'll be going into great depth about this because there's a lot of nuance to it and some pitfalls that you could encounter. So let's quickly go over what the form asks, and then we'll go into some depth as to what kind of information you might be wanting to get in here. So the form wants to know about parenting time. During parenting time, a guardian has the parental responsibility of making day-to-day decisions affecting the child and having day-to-day care, control, and supervisions of a child. Complete Section 3 below only if you're applying for an order about parenting time. Obviously, you can leave this section blank if there are no kids involved. So paragraph 3, I'm applying for an order about the allocation of parenting time as follows. I'm asking for the children to spend time with me as follows. I'm willing to have the following conditions placed on my parenting time with the children, and I'm asking for children to spend time with the other guardian as follows. Now, taking a step back from this form, going back to, pre-2021, the form that we're in, it really did not go into this level of detail. And one of the pros and cons of this new type of form is, for me, the pros are that you can be really clear about what you're looking for. It also makes it much easier for the person who's answering your application to figure out exactly what you're looking for so they can answer properly. It allows the court to tell straight off the bat kind of what your position is. But the cons are kind of the flip side of that. It makes your client commit to a position pretty early on in the game. And from either a support worker or a lawyer perspective, when we work with a client, it's so common that you're getting them at a very vulnerable time. They might have just separated. Lots of things might be in a state of flux. The living arrangements might not be certain. They might be really upset. And, as we all know, you don't have the clearest head, and you might not be the most rational about kind of what you want and what is in the best interest of the children when you're like super upset. And it also makes this a really overwhelming task to commit, straight off the bat as to really have a full plan. And for so many of my clients, they don't have it all figured out when they're like a week from, breaking up with their spouse. They don't necessarily know what they want. And to essentially write a mini essay about, what they're willing to do, what they're hoping to accomplish, you're really walking the fine line between kind of over committing straight off the bat and, maybe being too restrictive and too harsh. And then you become very positional. And I think, but what I mean by that is you also don't want to be unreasonable in your initial ask, because I'll say this is kind of your initial ask of the court and of the other party, right? This is like what you're saying, you're hoping to achieve and you think it's in the best interest of children. And sometimes because the beginning of a separation, everybody is upset. You also run the risk of putting something in there that you could later on regret. Obviously, you can, amend the form if you've made an error or if circumstances have really changed to make you, deviate from your position. But this is something that the other party will get and they'll read, and the judge will get and he or she will read. So they're really delicate things that you'd have to explore when you sit down with a client and you help them fill out this portion to really think about what are their underlying interests, what would best serve those interests, and to not get too positional. Like, sometimes people have a false understanding of what, I want to be the primary parent. I want all the responsibilities, and if you really work around that and you explore, well, if Timmy broke his leg, like, you would still tell the other parent, right? Which means you do, if Timmy requires surgery, you would talk about that type of decision with the other parent, right? To really, get to the bottom of, are they really looking to solely have all parental responsibilities? Are they just saying that, they would like those responsibilities, but they would like to consult with the other parents still about those important decisions? I think those are, and that comes down to perhaps you're going to need to send your client for an initial consultation with legal counsel to really explore those questions and, fully flesh them out. Or if your client have limited means, of course, you can, ask them to go to the Legal Services Society to see and call the law line and explore those options. But there's actually a lot more to it with these new application forms that certainly meets the eye. Now, in answering the first question, I'm asking for the children to spend time with me as follows. Here's where your client could put a very fully fleshed out schedule. If that's, it could be as simple as I want them to primarily reside with me. Or if your client was comfortable, you could talk about a particular schedule that works with their work and describe what the work schedule is and how that rotation would look with parenting time. Or if it's a shared schedule, what that would look like. If dad or mom works 4 on 4 off, how the children's time are going to be split if it was a rotational. You can even consider what the shift schedules would look like to talk about, when exchanges would be and what time they would be. So you can go into great detail when talking about the conditions to be placed on the parenting time with the children. We could talk about exchanges. We could talk about phone time. If you were really kind of getting into the nitty-gritty of specific things, many people will even put in a full holiday schedule. But that really is getting into like great detail. Now, of course, you might want to get into that amount of detail because if you didn't ask for it, you're not going to get it. So if there's a specific arrangement for the holiday season, say, Hanukkah is very special to your client and they would really, their side of the family are the ones celebrating Hanukkah, you might need to specifically state what your wishes are for the holiday parenting time here so that the other side can make a full reply and answer. If you haven't asked for it, you can't assume that later on the judge will be dealing with those specific topics. So you might also want to talk about holidays, spring break, Halloween, birthdays. There's really a lot that could go into, paragraph 3, other than, the simplest form would be shared parenting time or primary residence and just putting 3 words. But, that is not necessarily what it's going to garner your client the result that they're looking for with the amount of detail they're looking for. If, it was important to them to visit family overseas, once a year. That's something that you're going to have to add into paragraph 3 as your initial ask, if they need to be overseas for like 3 weeks of a year in order to do that. Any questions on this part of the form? Like paragraph 3 is a pretty huge and one of not the most dicey aspects of the form, but certainly could be the most instrumental for many clients. So let me know in the chat if you have any questions.
There is one question. Can it be point form?
Absolutely. Yeah. It can be in point form. I've seen lots of people do it in point form. In fact, I think it's helpful if you did it in like numbered paragraphs. If you have a lot of asks, instead of putting a giant paragraph, it allows later on, especially at a hearing, for you to kind of check each of them off, like, okay, regular parenting time is at paragraph, 1. Paragraph 2 is about, spring break, and 3 is about summer holidays. So it also allows a judge to clearly see, and, you can see the boxes are not all that big. So this is where you might say, please see attached Appendix A, or, attached to this form, and just have it typed up as like 1, 2, 3, 4, and 5, all your requests about various holidays. They would all go in here. Any conditions to be placed on, parenting time would go in there, and they can all be in numbered paragraphs.
Thank you.
Yeah, go ahead. Thank you. Okay, let's look at
I thought you were done answering the question. Sorry if I interrupted you.
Hey, no worries. So let's go to the next part of the form. Has a little box that says, I'm applying for the following orders about parenting arrangements. Now, this is just blank on the form, but this is where you might want to talk about a whole bunch of things, including, are there any communication requirements? It's pretty common for high conflict relationships to have communication requirements. This is where your client might say, yeah, let's limit all communication about the children in writing. You can say, limit all communications in writing by some method, email, text message, some kind of co-parenting app on your phone. You can also specifically request that the parties don't talk at all other than about, say, things about the children. So, this might be the case where one person feels harassed by the other. They don't want to get all those messages about, I want you back, that kind of thing. They want to just limit the communication to things about kids. This is where you would put in those communication requests. Now, exchange and transport is also something to be mentioned. That's not immediately, apparent when you're just looking at, I'm applying for the following other orders. It might not jump out at any of your clients. So this is where they're supposed to mention like how the pickups are going to go. If they're in different communities, who's doing the driving? Are they meeting halfway? Are they, sharing gas money? Does the parent starting parenting time always be the one that goes to pick up or drop off? I know a lot of times when you've got a situation where one parent is like, the other side kind of shows up once in a while, but is not always on time, etc., then it's probably important that the other side be the one to come to your house to pick up, because if they're late, you're not waiting for them at the side of the road, you're kind of at your home. So if they don't show, then you just carry on your business for the rest of the day. But the children are not otherwise inconvenienced. So that's something to keep in mind under the exchange and transport, talking about who's driving and who's picking up to start their time. Location of residence is also something that many people will talk about here, especially if they either want to move somewhere or they want to make sure nobody moves anywhere. So there might be a requirement that you could ask for, which is like, nobody move the children's residence, outside of 50 kilometers from Golden, or, not to change the children's schools. Those are the type of other orders that you might want to get into this, the answer to this question. You can also talk about travel outside of province and outside of country. As we know, sometimes it's difficult crossing the border, especially for parents who say don't share the same last name as their children. And So, you probably want some type of order, a court order that says you may travel with the children out of province and out of country. Other parents would be looking for specific clauses that, hey, if the other side does travel outside of the country and outside of the province, I want 7 days notice, or I want, a week's notice. I want exchange of travel letters. I want, ability to call the children while they're away every other day, or I want a full itinerary if anybody ever goes anywhere out of country for, more than a week, that I know where they're staying. I know I get a list of all the hotels and the ways to contact the children while they're away. This is also where you would put in those requests. Again, not immediately apparent on the face of the question, but certainly things to think about. Also, what happens if there are problems with parenting issues? Is someone the tiebreaker? Is there a veto by one parent? Must they go back to meet with their counselor if there are disagreements? And how to make changes to parental responsibilities and parenting time going forward. Like, is it a requirement that everybody must go back to a family justice counselor if there's a disagreement, or to mediation, or to their counselor? So these are things that you could ask for in this segment of the form. Now, as you can probably tell at this point, there's so much more than meets the eye on this application form. Budgeting-wise, it impacts your work and your client in a number of ways. First of all, whereas previously doing an application with a client might have taken you an hour, you can probably tell this is going to take many hours of work, many hours of exploring things, and many hours of just like committing your position in writing and getting it just right. So budgeting wise, it'd be making those appointments with these clients, doing up the form. It's going to, you're going to have to factor into, just how much information and how much detail and depth you'd like to get into the application. The budgeting also goes towards if you're hiring legal counsel to prepare this initiating form for you. From my own personal practice, I can say that it has drastically increased the cost of filing a provincial court application and getting it past the first stage. Papers handed in, waiting for a court date with a judge. Whereas, that might have taken 2 or 3 hours of legal time, meeting with the client, preparing the form. Doing a good job at this form is now going to be like 5 to 10 hours, depending on the level of detail we're getting into the form, and, just how much exploration you're doing with your client, which means budgeting for hiring private counsel, or even with working with your legal aid counsel to build a form that, has all of this information. It's going to eat up a lot more of the originating time than was previously, likely going to be the case. Although one can say it just kind of front end loads the process, because these were all things that would have needed to have been figured out by the time, you get in front of a judge anyway. I guess where, money-wise and financial-wise, your client would need to be aware of, they're going to need to come up with a much larger retainer straight off the bat. Whereas previously you had months and months to get this detail down enough for your lawyer to go to court for you, say for your, originating family case conference back in the day. You need to now come up with the entire retainer straight off the bat so your lawyer can properly prepare these forms before you can even file. So, that's likely the difference budget-wise in terms of hours of preparation. Any questions at this point about this segment of the form before we move forward? Hearing none, let's talk about the next part of the application. which gets into a mini essay about the best interest of the child. Now, you're going to have to write about, I believe the order about parenting arrangements I'm applying for is in the children's best interest because, and now this portion is, you could really, for some, write a long essay about this. You know, you're talking about the children's emotional health and well-being. You're talking about the children's views. You're talking about the children's relationship with parents, guardians, and other important people, the history of their care, the impact of any family violence. If you looked at even each of these, they could be like, you could write like a 3-page essay about why your proposal is in the children's best interest. Of course, you're expected to take, you know, reasonable kind of view of this and, you know, not go into crazy amount of detail. But bear in mind, I think there's a couple of things to think about. We'll get to the family management conference, where this part of the form will get looked at. Under the new rules, the family management conference is very different from a first appearance. Previously, at the first appearance, unless there was a notice of motion on the table, judges do not make orders that are not by consent, that are beyond administrative in nature. The new family management conferences, judges can make interim decisions. And the evidence that they're drawing from is this form. So, you know, the danger of not putting in enough content in this form is that your client's going to be at risk of the judge making a decision without them fully having, you know, the client fully having put out their narrative. So, you know, if there are going to be high impact decisions being made, even on an interim basis at the appearance where they look at this form needs to be done well. You know, it's not something that you should just gloss over by having one line answer. I believe this is in the best interest of children because, you know, is the status quo. Let's say that's all you put. That is all the judge is going to be making the next stage decision on. That's not much to go on. So, you know, if you gave just a very cursory answer to this question, I think you're running a huge risk of a decision being made at the family case conference, the family management conference, that is not going to be in your client's favor because their evidence is not fully before the court. In fact, to me, the answer to this question looks very much like what you would put in an affidavit in Supreme Court. The flip side of that in terms of preparation, of course, like it's going to eat up a lot of your time to get too far down the rabbit hole with these questions. If you put in too much, you also run the risk of the judge not being able to fully review because, you know, you're now handing in a 30-page document. The judge is not going to have the ability to review that before the hearing. So while you want to be relatively succinct, you certainly need to hit on all 5 of these high points. Now, as support workers who are going through this process, as a tip, I would suggest that you go through relocation decisions that are available on CanLII. So CanLII is a source of legal database of previous case law, where judges have made decisions on just about anything, parenting time, relocation. The reason why I'd suggest that you just take a good read of some kind of provincial court relocation case or a Supreme Court relocation case is because they always have a segment in the decision that reviews these 5 topics. So you kind of read 1 or 2 and you will get a very strong sense of how to answer these questions and what you're really supposed to be saying based on your client's situation. So I would really suggest that if you want to study a little bit to better help your clients prepare to the answer to this question, that you take a look at those decisions about relocation. all you need to Google in the search terms would be BCPC, so British Columbia Provincial Court, and then the word relocation. And if you scroll through those decisions, you will find at least, you'll find dozens and dozens of them that will go through how to answer this best interest question.
There are two questions there.
Yeah.
Excuse me. Yeah, there are two questions there. Can I ask you now, or you want to?
Oh, yeah, absolutely. I can answer those questions. Does legally allow for more hours to deal with these new forms? I think there are set hours overall based on each person's legal aid contract. Ministry files have their own time limit for how much time you get to spend on your family law case. Family law cases have preparation hours overall for general preparation. And so I think it's up to the lawyer to work with the client to set some expectations about how much time they're spending on these forms to get them to go, and for the client to really get a sense of how much time is left for everything else beyond this first stage. Now, Aaron's question is about what is the website to review case law, and it's called Canly. So I just typed that into the chat, CANLII. Okay, let's check the time. We're 44 minutes in, perfect.
Yeah, thank you, Karen.
So we're on to the next schedule of the form. I've skipped ahead to the child support schedule instead of talking about changing agreements or court orders. In those ones, your clients will have to talk about what's the material change in circumstance that's occurred between the last thing that they signed and now. That will be the highlight, again, to support clients in determining that, what to say and what to put in. The trick would be to go through Canly, Google material change in circumstances, and see what kind of things qualify. And that will give your clients some inkling as to how to best present, their facts when they're seeking for a change from a previous order or a change from a previous agreement. Now, filling out the child support schedule. This is vastly expanded from the previous forms. It is long and it is quite arduous. So let's go through it. The current support arrangements are as follows. This is a simple question, is anyone paying anything right now? Next, do you know the income of the other party and what do you believe it is? That's also relatively straightforward. This is usually what's the T for line 150 type income opposing party has. 6 is perhaps the toughest question to answer. I know the following facts about the other party's employment, training, health, and ability to work. Now, from a lawyer perspective, when we read that, we know what they're getting at. They're answering what is known as an imputation of income question. This is where the other side is not, for whatever reason, fully, availing themselves of employment opportunities. This is where people are intentionally underemployed, and for some reason, either shortly before the separation, during the relationship, or shortly after the separation, they decide to quit their jobs, drastically reduce their income, or do something that may be nefarious or may be due to legitimate reasons for parenting or health reasons. But what number 6 is getting at is what's their income earning potential? Now, this is going to require your clients to really explore what is the other side doing and what's their status? Are they working their normal jobs? Are they not? And why? Their ability to work. There's a lot of things to go in there. In the spousal support section, there's actually a flip question that is identical to this, but that's about your client. We'll get to that shortly when we discuss the spousal support schedule. But here, if your client has any indication at all that the other side is going to be underemployed, question 6 needs a lot of information. Because again, this is where at the family management conference stage, you could ask the judge to impute an income and start a child support payment. So, you need to attach information about, hey, in the last 3 years, their tax return said this. They all of a sudden quit their job. It's not due to health reasons. They have a ticket in, welding or whatever. So there's a lot of information to get in there if you're looking to do an imputation of income claim. Next up, question 7. I'm applying for an order for ongoing support to be paid by the other side in the monthly amount set out in the child support guidelines for the following children, and then you list the children. So here, your client might need to have done some homework and looked into the federal child support guidelines about, what would be appropriate. That also goes to answer question 5, which is what their income likely should be. 10, you have to attach calculations. Select only one of the options below. I'm attaching calculations showing how much child support I believe should be paid according to the child support guidelines. So again, this is not original forms prior to 2021. You certainly did not need to attach calculations. This would be something that you would only likely prepare at a hearing stage. But like I said, because at the new, essentially first appearance, which is the family management conference, the judge can make substantive interim decisions about things like child support. Your calculations have to be in now. So calculations are, you can do it by a number of ways. There is a free website called My Support Calculator, which will generate based on the information you provided, like where the kids are living, how old are the parties, what are everybody's incomes, what percentage sharing they're at. They will generate something that you could print out to show the child support payable. 10 is a tricky one to answer when you don't know what the child support and parenting sharing is going to be. You're likely going to have to help your clients prepare a number of calculations, sort of like a plan A, a plan B, and a plan C, or maybe even more plans than that. And I'll explain why. Child support is dependent on the proportionate sharing of the children's time with each parent. If you hit more than 40% per person, you're in a shared parenting relationship, and your child support will likely be based on an offset of some kind if you're doing a strict guideline application. Otherwise, if you're less than, one parent is less than the 40% mark, then you're in a primary situation and your strict guideline numbers, there's no variation. So if your client here have asked for primary, well, they're not guaranteed to get it. If the other side counters with, well, I want shared, and they get it, and the judge agrees with a shared arrangement, your child support is going to change. So first of all, that already immediately means your client needs to create 2 sets of calculations, a primary calculation based on the tables and a shared selection based on the tables. So that's already 2 sets of calculations. Now, if your client is uncertain about either their own income or the other side's income, now we're looking at like a myriad of various calculations. You might have to do some calculations based on your client at, say, $20,000 and the other side at $50,000, but maybe, with bonuses, their income should be $80,000, or you think they're under declaring in some ways. So now you have to do 2 sets of calculations, a 20 plus 50 and a 20 plus 80. Alternatively, your client might worry that there's currently at no income, but maybe they should be working. So what if like an income is imputed on them? So as you can see, answering paragraph 10 and attaching all those calculations, it could be quite the process just to run through all the scenarios that you want to present to the judge as a kind of a plan A, a plan B, and maybe a plan C in the alternative. There's also a risk of maybe giving too much information at this stage and giving away your position. I don't know if you're really seeking for an imputation of income at an $80,000 mark, that it would really be in your client's best interest to include, a $50,000 calculation just in case. That is really a strategic decision that your client needs to make, likely with the help of legal advice, trying to figure out, what really they should be presenting when they attach those calculations. Sometimes there is an undue hardship claim. If you do that, you'd have to answer paragraph 11. Now, heading into paragraph 12, special and extraordinary expenses. First of all, you could check a box if you're not applying for any. More than likely, your client will be applying for some. So it says in second box under paragraph 12, I'm applying for an order for special and extraordinary expenses under section 7. The following special and extraordinary expenses, net of tax credits, subsidies, etc., are included in my application. That is such a loaded question. Usually, you would present this information in a financial statement, which again is typically not due for some time, and it gives you some time to do that. Here, even in the initiating application, you need to fully prep your clients to answer what are all of their special and extraordinary expenses for their kids. So this is your client combing through every skating receipt, every swimming receipt, any hockey receipts, any of the equipment related to these things, team fees, competition fees, maybe there are travel costs, maybe there are ski passes, maybe there's like music lessons, perhaps there's preschool, daycare. If they have medical needs that are not covered by a health plan, orthodontics, all kinds of things. You need them all. So that tiny little box is probably not a good reflection of just how much detail you're putting in there. There's likely going to be an appendix with a lot of, calculations. And your client also needs to calculate what is like the net amount versus the gross amount, whether or not these things are recurring monthly or annually in terms of like team fees and signups and that kind of thing. Again, this is usually what would go into a financial statement. And in fact, it will be repeated when you do your financial statement. But this is another one of those things. You don't want to under-declare. If you don't declare it, you're not going to get it. So if your client forgets about, I don't know, swimming or skating, later on, they're going to have to add this information back in, and they're certainly not going to, have that information in front of the judge, so the judge could probably assess that expense. So in terms of meeting with the client for the first time, trying to get them ready to fill out this form properly, remind your clients that they're going to need to collect receipts from the past 12 months, and have that information fully prepared for you so you could really help them fill out this portion of the form. So before we move off child support, are there any questions about how to complete this new schedule?
There are no questions so far in the chat.
Okay, so what if you make a mistake? Great question, Travis. This form can be amended, and you can certainly file an affidavit later on, or a financial statement you can correct by adding that new information in your financial statement. So that's how you would deal with mistakes. What you don't want, though, is fundamental inconsistencies that are more than just mistakes. And yes, a financial statement will need to be submitted as well if you're making a claim otherwise for special and extraordinary expenses. So what I mean by inconsistencies is mistakes are mistakes. So if your client honestly got it wrong, then of course you're going to correct it in your financial statement. You don't want your client to appear to be lying. It's basically what it comes down to. That's where the inconsistencies get dicey, and that's why you do need to do a good job on your first form. If there are now more than one typographical mistake, and it looks like your client is just like unbelievable because what they stated in their originating document is vastly different without explanation from their financial statement, we're going to have problems at trial. So that's where, you know, it goes to your client's credibility. Like, where were you telling the truth? You know, so you got to be pretty cognizant that you can't be like internally too inconsistent between what you're stating at your originating application and what you're following up with either at your testimony at trial or in your financial statement, because then it just raises questions of, well, is your client lying or confused? So as described, you know, you're now looking at listing out all the annual amounts for each of these expenses. You got to fill out this chart per child in this form. Then to the question of whether or not a financial statement must be submitted, it actually does say you have to attach a financial statement at paragraph 13 if, you know, you are making an application for special and extraordinary expenses, or if any of the other options apply. So on to the final big schedule that requires a lot of thought, which is now Schedule 9. Schedule 9, spousal support. So it says that I believe I am entitled to spousal support for the following reasons. Then you got a whole bunch of boxes that you should check. Remember, check all that apply. Don't just check one. In all likelihood, actually, all four will apply. So you certainly don't want to undersell your client by missing one of the boxes. This is where in almost all circumstances, if you're asking for spousal support, probably all four boxes should be checked. Travis asks, is there ever a time where you put too much info in? I think there could be. Like I said, you don't want to put in so much information as to overwhelm the judge so it's too confusing and you've got like 20 pages of attachments that, you know, then it's not immediately apparent to the judge what they should be looking at. There's also a chance of wasting too much time. Say you're hiring someone privately or through legal aid to deal with these forms, putting in way too much could be just wasting too much time. And finally, you could put in too much info by offering too much information for the other side to critique you on. And that leads to, you know, the danger of running into future inconsistencies. This is more relevant to the portion of the form that I'm going to chat to you later about protection orders. So we have to be very careful of the information that we put in there, putting in too much info versus too little. When we hit that part of the form, I'll specifically alert you to where you could run into problems putting in too much information. Now, onto this part of the form, remember I talked about you're going to have to state your information about your own income earning potential. That is the question to number 3. My current employment situation, training, health, and ability to work are as follows. Of course, your client is going to need to give a full answer there. But this is maybe where you could go wrong as well. You know, back to Travis's question, could you put in too much information? You don't want to overcommit your client at paragraph 3. You know, you're stating what they're, you know, if your client doesn't think she's going to be able to work full-time or he's going to be able to work full-time, don't put that into paragraph 3. You know, be very cognizant of what your client is signing up for in terms of the answering the full income earning potential question. So I do see another. Would the judge request extra information if needed, or would they say it's incomplete? Absolutely. You know, the judge may require parties to hand in additional financial information or to put in a supporting disclosure and exchange that disclosure at a later date at a family management conference or at a family settlement conference. And Katie's totally right. The judge would then make that very clear at the court appearance. Oh, I think I skipped ahead too far. Okay. Next set of questions for the spousal support schedule. These will look very similar to the child support questions. Select one of the options below. Do you know the income of the other party? You've got to check box 2 if you're seeking an imputation of income. Okay. If you blankly say you don't know what the income of the other party is, it's going to be very difficult at your first appearance before the court to ask the judge to impute an income. If you're seeking an imputation, you've got to have checked off box number 2 and suggested an income so that the other party, when they make their reply, can fully answer your request. Number 5 is going to be identical to previously. If you've asked for child support, what their employment and training and health and ability to work is. And 6 is a hard one. Let's look at 6. I'm applying for an order for spousal support to be paid by the other side. And you've got 3 boxes. In the amount of blank to commence blank until some other time. Second box, in the lump sum of some amount of money. And third box, other. I can tell you that even family lawyers who have done it for years and years would have great hesitance answering question number 6. And this is because spousal support is amorphous. What if your client gets sick? What if her income decreases or increases? What if his income goes up or down? What if they need to go into a training program? Answering the question until could be a huge limiter to your client's case. Even the child support and spousal support advisory guidelines, if you ran through DivorceMate or the My Support calculator on the spousal support question, it would give you a range. It would give you a low, mid, and high range for spousal support, and it would likely give you a minimum to a maximum range in duration. So be extremely careful answering the final part of until. You do not really want to put an end date if you don't have to. Because you don't have a crystal ball. Nobody knows if your recipient is going to have some health problems, 5 years down the road. And you certainly don't want to limit him or her to a specific answer. You might just put there unknown. I would really be super cautious also answering the lump sum number. Even for lawyers, the lump sum, there's tax implications to that. There's ability to pay, you have to look at the longevity of the person, maybe discount for life expectancy. There's a gazillion factors that goes into calculating a lump sum. That would be, I would extremely be very hesitant answering 6B. I'll call it box B because it's the second box, or C. The other one is, and also answering the duration question. Just be very hesitant. You might select other by saying just pursuant to the spousal support advisory guidelines and leave it at that. You might even put in more information and maybe say it's an interim amount of something, of some quantity, maybe in the mid-range of the guidelines. And if your client's income is not totally set in stone and the other side's income is not set in stone, answering question 6 could really come back to haunt you. So be very careful answering this question. There's definitely some pitfalls in answering this wrong to begin with. And it's you might just want to stick with mid-range of guidelines and just leave that as the answer instead of signing up for some number that you might not be happy with at trial. So before I move off of spousal support, any questions on this schedule? It is a very tricky schedule to complete when you really think about it. And let me know if you have any questions. So let's check the time. We're now at noon, or 12:07, so we have about 15 minutes left. Okay. So let's touch on some of the other portions of Form 3. So we're still on the first form, guys. I'm so sorry, but there's a lot to the first form.
I have a quick question. The time is 11:07.
Oh, right. Sorry, I'm in Mountain Standard Time, so here.
Yeah, that's what I thought.
But we still have the 15 minutes, so that's good. Okay. So we're on to the other side of the schedule. Like I said, there's a schedule to fill out if you're replacing or setting aside an existing agreement of order. If your client's filling those out, make sure he or she is going to go read some decisions about those things and look at what would amount to a material change in circumstances in order to seek some kind of a replacement or the cancellation or a variation of an existing claim, or get some independent legal advice on that question. There's also a portion of the form where you're applying to become a guardian. In certain circumstances, parties are not automatically guardians. Sometimes if you're parents to children and you were their parents before separation, you're automatically deemed a guardian in some of those circumstances. But other times you're not. Like, say you've never lived with the parent of your child, or you kind of separated before the birth, and you don't regularly care for them, you might not already be a guardian, or it might be a grandma or grandpa applying to be a guardian. Then you got to fill out the appointment of guardian schedule. If you're doing that, the form alerts you to the fact that you need to complete a guardianship affidavit as well as a criminal record check. There's like a ministry check component. So you've got to do those supporting forms if you're applying to become a guardian. So just be cognizant of that. Also, there's a requirement to declare the Indigenous ancestries of the children, and be aware that your client will need to serve the Nisga'a government or the Treaty First Nation in order to start their guardianship application, and then the courts will have to consider those laws and customs in making its decision. Now we're finally on to the second form. So we're on to the reply forms. So of course, if one of your clients have been served with one of these applications, then you've got to do the reply. The reply is in Form 6. At that point, your client gets to do their own version of the application form in the form of a counter application. All the same schedules, all the same questions. Now they get to put in their side of the story. If you're the initiating party, once you get served with a counter, you get an opportunity to reply to say yes or no to some of those requests. So that completes the first segments of forms, which are Forms 6 and 8. Of note, if straight off the bat, everyone already agrees, they know what parenting arrangements or support arrangements they want, parties can submit their entirety of their consent in a consent order form, along with an application for a family law matter consent order in Form 17. So this is where no court is required, and you're looking to essentially have a judge not require an appearance and just hand in your consent. When the judge gets that consent, they can either make the order sought as is, they can maybe make it with some changes, they can write back and ask for additional information to be handed in, or they could say, no, this is a little too complicated, or they might have questions about your client's consent, such as there's something weird in there, not being paid according to guidelines, some type of relocation is suggested without, adequate parenting time to the other side. They might then set a court appearance and summon your clients to attend, or they can ask your client to give notice to the other side or some type of direction, or if it's flat out something that is totally outrageous that people have put into their consent order, the judge could reject it, providing some reasons about why they don't think it's acceptable. So those are the basic forms that are to start. Now, on to